Good afternoon, I'm Claire Wiesel. I'm the Communications Manager for Composites UK and I'll be facilitating this afternoon. Welcome to the webinar on understanding intellectual property. Our speaker today is Mark Scott, who is a partner in Elkington Fife. He'll give us an overview of intellectual property and patents with some examples relevant to the composites industry. We are recording the webinar, so we'll share this and the PDF of the slides within the next day or so. If you've got any questions, please can you put those in the Q&A box at the bottom of the Zoom screen. You might need to whittle the mouse a bit to make that pop up, and we'll go through these at the end. And with that, I will hand over to Mark to begin his presentation.
Thank you very much. As Claire mentioned, the idea for today's talk was to provide an overview of intellectual property. I will try and make it as relevant as I can to the type of work that you'll be doing, or what I understand is the type of work you'll be doing. And really the aim is to give you the tools to be able to identify what type of intellectual property might arise in your day-to-day work, why you might want to protect it, and what you can end up doing with it. I think really the presentation will be broken down into two parts. The first is a brief overview of the types of intellectual property that you might be more familiar with, that is copyright, trademarks and designs. And then I'll give you more of an overview on patents and try and provide some examples from my practice as to what we tend to find is useful and where people find IP helps them to develop their business basically. Claire briefly mentioned my background, but just to provide you with a bit more information, I'm a chemist by trade. Analytical chemistry is my background. Before I became a patent attorney, I worked for the Ministry of Defence, specifically in techniques such as gas chromatography, HPLC, and since then I've kind of developed into a materials scientist. Whether that's a good thing or not, I'm not sure, but the technology is certainly much more interesting for me now. And my clients tend to be in the fields of inorganic chemistry. So one of my large clients is Corning Incorporated. They're a glass manufacturer. They also do a lot of ceramics, a lot of composite materials. And I also work with quite a lot of UK-based entities who are developing composite materials, lots of interesting new aerospace material designs, and generally as well just a broad range of people across engineering, lots of people in sheet piling, wind turbines. And so I see quite a lot of the types of IP that really helps them to drive their business and where possible get investment, stop others from infringing on their IP. So that's really the aim of the talk. Intellectual property is a strange term, but really what it just means is it's a right that arises from any creative endeavor. The idea is that in return for you putting in some time and money, whether that's research or investing in others researching for you, you really should, or the idea is that you really should get something in return for that. So some sort of protection to stop others from copying your idea, and to stop or to allow you to exploit it in the best way you can. These rights vary. Some of them arise automatically. Some of them you have to register. But the key is that it stops other people from exploiting your gains without your consent. These rights are territorial. I'll give you examples of this as we go through. But what that means is if you develop something in the UK, you can apply for protection in the UK and also other jurisdictions, but the protection in the UK will apply to the UK only. Other jurisdictions include Europe. Some of the rights are EU rights, some of them are more generally a European right, which incorporates other territories. But you may also want to obtain protection further afield. The US is a big market, China, and so on and so forth. So you should always bear in mind when you're thinking of IP that you'll need to consider markets, where you might be making it if you outsource production, for example, where your competitors are based. All of those factors will help guide any decisions you make about intellectual property. So the four main types I briefly mentioned, these are the ones that you've probably all heard of: copyright, trademarks, designs, patents. There are some other rights as well, for example, trade secrets. I won't go into trade secrets in much detail, but ultimately it's just the opposite of applying for a patent. Rather than letting everyone know what the invention is and receiving protection, it's just keeping it a secret. So the landscape of IP is that they all overlap in some way, shape or form. Each of them has its own field, and then there are inevitably grey areas. The one I'll just briefly talk about now is copyright, because I won't go into too much detail. It's less relevant to the type of work that we tend to find in materials-based industries. It's primarily for literary, dramatic, musical and artistic works. So you might be familiar with copyrighting songs or copyrighting performances. But it can actually still have some use in our fields. And really where you see that is in the development of literature. So if you're creating manuals or marketing materials, copyright will automatically arise once you've made that. Similarly, software and graphical user interfaces is another place that it can arise. And really the key considerations are, you want to just make sure that if you're using somebody else's materials, that you've got the rights to, and vice versa. If you're getting somebody to create materials for you, for example, if you're outsourcing things to a design house or a creative licensing agency, or any kind of agency, you want to be reading the contract, making sure that you at least understand where the rights will subsist once the work has been created. But much more relevant is what we call industrial property, another type of IP. And this is essentially the kind of umbrella term for patents, designs, trademarks. And so I'll talk about these in a bit more detail, starting with trademarks. This is something that pretty much everyone has heard of in one shape or form. And the idea is that a trademark is, or a mark is a sign that designates an origin of a good. So that can be a brand name. That's the most common implementation of a trademark. So we have companies like Apple, Dyson. Those signs indicate the source of the goods. So you know that if you're buying an Apple product or a Dyson product, it's going to have certain quality attached to it, and you know that you can, well, rely on that product. So IP allows you to protect that reputation that you've built and protect your brand. But it does go beyond that. Trademarks also allow you to protect other forms, logos, slogans, and really where we see that most in the composites industry is not just a company's name, but also more commonly now product names, as people try and differentiate their products from others, especially when you're dealing with large supply chains and, you know, product codes aren't quite as well remembered as interesting names. One example that I find quite interesting is, I mentioned Corning. Now, some of you may have heard of one of their products called Gorilla Glass. And in creating this brand around a particular type of glass, they've somehow managed to take what's quite a typically standard piece of an electronic device, the glass screen, and turn it into something that people actually look for in a device, which is quite an interesting way to do it. Of course, not everyone's going to get that kind of recognition on component parts of products, but it's worth bearing in mind that if you are creating products and you're coming up with names, or you're building reputation in those products, trademarks can be an interesting way to protect it. I've picked up on the Composites UK logo here because I know they've applied for a trademark in the past. I think it didn't go anywhere, but it's just to give you an idea. So trademarks can be words, they can be just the name, for example, the name Dyson, and Dyson might be able to protect that in any context. Logos, on the other hand, are stylized versions of words. So Composites UK clearly has some stylized UK, and underneath the UK is a trade association, and that makes it more unique, which will increase the chances that they may be able to obtain a trademark. So there are two ways in which you can get a trademark. By far the best and most effective way to get the trademark is to apply for a registered trademark. That will ensure that the rights are publicly known, and you can use this symbol that you've probably all seen. The other way is by passively acquiring rights. So if you've been using a name, you will be passively acquiring rights in it. However, it really isn't as strong, and it can be very difficult to enforce. So the take-home message is, where possible, consider registration. It's a pretty straightforward procedure. My advice would be to seek the advice of a trademark attorney if you're unsure. But actually, it's a process that a lot of people undertake on their own, and they tend to only look for representation if something goes wrong. But either way you look at it, make sure that you're making a decision as to whether you go down the route rather than passively acquiring these rights and then later encountering problems. So I mentioned that the rights are territorial. With trademarks, for protection in the UK, you can apply to the UK IPO, which is the UK Intellectual Property Office, and they will examine your trademark. And then if it's accepted, you'll have protection within the UK. Alternatively, you can apply to the European Union Intellectual Property Office, and your right will cover the whole of the EU. That's a lot more common at the moment. Obviously, that will change in time, or it most likely will change, and I'll touch on that a little later. But those are the two main options for a UK residing company who wants to protect their brand in the UK. If your company does business elsewhere, or you think you might do business elsewhere, you can expand this out to other jurisdictions as well, but you'll have to apply to those offices separately. There is an international application that assists with that as well. But if there's any specific countries you want to file in or you want to move into, you do need to think about protection there as well. Just a very quick overview of the process. This process is something that I'll mention with respect to designs and in more detail patents as well. But essentially, you will apply for your mark. In this stage, you decide how you want to represent your mark and what goods and services you want it to cover. So you don't want to cover everything because it increases the risk of you clashing with someone else's mark. For example, you might use a name in the field of composites, but somebody else may use that name in food production. Then it will be examined by the Intellectual Property Office. They'll look to see whether it's capable of being a mark. I mean, people really do push the boat out with types of things that they try and use to designate their products and services. Some of you might remember back in the days of VHS, there was the MGM line roar at the start of every film. Somebody tried to trademark that. IKEA have tried to trademark colours, blue and yellow together. I think Cadbury's have tried to trademark purple. And so the Intellectual Property Office will push back as and when they see fit. And with trademarks, opposition is quite common. That's where somebody else has a similar mark and they think you're trying to claim too much, and usually it ends up with some form of negotiation, and people tend to come to an agreement. So the key take-home messages for trademarks are: consider registration, particularly for your key brands and your key products. It's quite a cheap process. It can be quite a quick process, and so it's something that you can do with not too much difficulty. But my advice would always be to talk to a representative. I work with several trademark attorneys, and it's very common for people to approach them, and they'll tend to give them all the advice they need without having to engage them formally. So that's a way forward if you're cost sensitive. So moving on to something that's probably a lot more product focused, and it's something that you might already use, and that's design right protection. What it covers is the appearance of a product. So what I mean by that is its shape, its ornamentation, in some cases the surface decoration of the shape, and the kind of places we see this are housings for components. So lots of people protect housings for cables, fibers, and then that ranges on to things like bathtub shapes, anything really that has a particular appearance that you might want to protect. Packaging is another field that's commonly found in designs. And really what it gives you is it gives you a narrow form of protection for that particular design and anything that's quite similar. Probably the biggest case in the UK related to the trunky children's suitcases. You might be aware of them. They're the ride-on suitcases that look like animals. They had filed a number of designs, albeit they hadn't quite captured the design as well as they could have, and ultimately I think their action failed. But it went all the way up to the Supreme Court in the UK, and essentially it highlighted that when you're filing designs, you really need to think about what it is you're trying to protect. So you need to decide how best to capture your design. And usually that will be in line drawings, sometimes in color pictures, sometimes in color drawings. But if you're going to file a design, it's always worth thinking very carefully about that. And the European Intellectual Property Office has huge reams of detailed guidance on how you might want to do that, or you can ask any questions if you have any questions about that. So designs, like trademarks, have two types. There's registered rights and there's unregistered rights. The registered rights are where you apply. Again, it can be the UK or the EU. There are other protections in other jurisdictions as well, but for us, the most common is the EU design right, at least at the moment. And what that gives you is it gives you a monopoly right which lasts 25 years for that particular design. But unlike the trademark route and patents, the registered rights aren't always examined. In the EU, they're not examined. So you can file something and have it registered within 3 days, 2 days sometimes. And so it can be a nice deterrent. It's a very cheap way of getting a deterrent to stop other people using your design. You would subsequently have to prove that it was valid when you bring an action, but that's something for later down the line, and that's something that's quite subjective, so it can serve a purpose without necessarily having to undergo quite a detailed procedure. On the other hand, there are these unregistered rights. Like with trademarks, you should not rely on these, at least not in the first instance. The consideration should be, do I actively want to protect this or not? And unregistered rights are kind of there to sweep up any issues that weren't dealt with, or if you've subsequently found out that something you didn't protect actively has been copied. The difficulty with this, I won't go into detail because it's a complex set of circumstances, but often you have to prove that somebody has actively copied your design with unregistered rights. So they need to have somehow seen your design and consciously or subconsciously copied it. Whereas with the registered rights, it doesn't matter whether they've ever seen your design. They could have independently come up with this idea. The question is just, is it the same or similar? Okay, so the practical points. Designs have to be new, and they have to be not similar to anything that's been created before. The trouble is if you disclose that design before you apply, then your application will be for a design that's no longer new because you have already disclosed it. And disclosure can be either by selling the product or by advertising the product or just letting any member of the public know about the product or showing them the design. So you should always consider applying for registered rights before you disclose. There are some grace periods in various countries, including the UK, but they're extremely limited. So they should be used only where a mistake has been made rather than relying on them. Those grace periods essentially allow you up to a year in some countries, 6 months in others, for you to disclose it and then subsequently file an application. But I would strongly recommend that you don't rely on those because there are lots of ways in which the application can subsequently fall down. As I mentioned, the EU IPO registration is very quick and relatively cheap. So it's something that a lot of people use and use as a deterrent. The final point I want to mention is similar to copyright, in that if you're outsourcing your design work or you're using somebody who isn't, for example, an employee to design your products, you need to make sure that the ownership is clear in any agreement that you have. And if there is no agreement, make sure that you put one together. You can always ask any solicitor or trademark or patent attorney to put together an agreement for you, or there are usually lots of resources online that might be able to help you with that. But if you don't specify it, there are backups in the statute, but it may not go the way that you intend it to go, and somebody else could end up owning your IP. Okay, so the final point of the whistle-stop tour of designs and trademarks is just a brief note about Brexit. So as I mentioned, it's very common for people to have European Union rights that cover the UK. Assuming that the negotiations go the way as it is expected, the effect of the EU statutes which govern these designs and trademarks will no longer be in effect in the UK. So the key point here is that some of the rights will transfer over automatically, some of them you will have to take some action, and certainly all of them you'll need to make sure that you keep in force over time. So I've put this slide together so that if you have any rights, you can read through and get the information. But the key point is to speak to a representative if you have any EU rights, or if you already have a representative, talk to your representative, make sure everything's in order, because there is a risk you could lose those. And given that the UK market is probably one of your biggest markets, that would be problematic, and you may not be able to recover them after that. So on to patents. The idea here is that I'll give you an overview of patents and give you some hints and tips towards the end, some practical tips. They do apply in some circumstances to the other IP. I just think that patents is an easier framework in which to explain the benefits and the potential downfalls of the IP. So you probably have come across patents in one form or another. And what it is it's a right that protects the idea or a concept, not just the single specific implementation. So patents allow you to protect an idea without having somebody change minor parts of the product and get around your protection. So in many ways, they are a lot stronger than designs. it also makes understanding patents a lot more complex. One of the myths I often find is that people think of patents as protection for large inventions, eureka moments almost, but the key is that they protect both large innovations, but also these incremental improvements. Most of the inventions that I deal with in the materials field are these small incremental changes. What you need to ask yourself is, have I solved a technical problem? If there's an improvement or a solution to something that was problematic, then there's often an invention. Just to give you some examples, back to the glass manufacturer, one of their major inventions 20, 30 years ago was the development of a particular glass overflow method, whereby they could create these very thin glasses with pristine surfaces on both sides, and that's what allowed them to use these glasses in mobile phones and other electronic devices. Now, the original patents for those inventions are quite old and have long expired, but over the years they've managed to make incremental improvements to this process, improving the quality of the glass, the reduction in impurities, making it greener, and they've patented each of those inventions as time marches on. So once the original patents had expired and people were able to use their original method, they had developed the glasses to a point where their glasses were much better than their competitors' glasses produced by the original method, and they still have that competitive edge. With things like glasses, you can protect compositions, you can protect the methods of manufacture, you can protect apparatuses for manufacturer, so the actual devices they use to make these glasses, for example, or any materials. And in some cases, you can protect new uses for old materials, for example. I had a client that created biodegradable airdrop boxes, and they used something which was quite common in the field of cardboard boxes, which was a cardboard box with honeycomb cardboard, but they still managed to get protection for its use in a particular way in a parachute, in an airdrop box. And that came to be the central part of their business. Just briefly, laminates is another industry we see quite a lot of IP in, particularly different combinations of layers, different combinations of known materials. We see quite a lot of work in these novel material fields, aerogels, graphenes, anything like that the properties are known, but together they can combine to provide improvements that are unexpected or compared to existing materials much better. And of course, you can more generally protect types of devices and other methods as well. Why do we bother patenting? The obvious answer is to prevent competitors from using the technology. It seems like quite an aggressive stance, and there are reasons why you may want to do that. But similarly, a lot of companies will use them in a defensive way. So what we find is that a lot of companies will say, and I think Cisco Technologies was one of the big companies that started this trend, and they said, we will not actively pursue anyone with our patents, but if you pursue us, we will retaliate. That's quite an interesting stance, but it has real utility for smaller businesses where they're fearful of being bullied by bigger companies. If you patent your technology, you can assert your patents against the competitor, and you can also use it to stop them from patenting similar technologies or your technology if that's a fear. There are also other ways you can exploit this IP. So, for example, if you want to license out a product or a process to a third party, almost like a franchise model, you can do that. Or if you don't think you'll be exploiting it yourself, you can always give people licenses in return for royalties. It's also quite a good marketing tool for obtaining investment and just showing your customers how advanced your product is. On the other hand, you do need to consider whether it's worthwhile. It's not always a cheap process. And so you need to think about factors such as, could somebody actually copy your invention? If your invention is a process and they'll never be able to figure out what the process is it worthwhile patenting it, or would it be safer just to keep it as a trade secret? What we find as well is that often people will patent inventions that they wouldn't be able to tell whether somebody else was using it or not. So in some countries that can be quite effective. In Japan, we find that a lot of companies will never infringe a patent knowingly, whereas in some cases people are much more willing to try and ride their luck. So you need to think about whether it's something that you will actually actively enforce when making that investment, because if not, it might not be a worthwhile endeavor. So much like trademarks and designs, the patenting process involves, first of all, applying for a patent. The reason I want to mention this is because it's at this point, it's very important that you think very carefully about the invention. And I would strongly recommend, if you're thinking of obtaining a patent, that you seek representation, because if you've ever read a patent, you'll notice they're written in a very particular style, and it's somewhat bizarre language. But what it is it's our way of trying to capture the concept of the invention and make sure that people can't just tweak unimportant aspects in order to get around the patent. And if you don't use that style and that language in the particular form that's required, you can end up disclosing your invention but getting no protection in return. So the application stage is very, very important in the patent application process. And once the application has been filed, it's very difficult to work backwards and resolve any issues. So if you're considering it, you need to consider very carefully whether you should be seeking representation at that point. Once it's filed, it's much like designs and trademarks, in that the patent office will look at it and determine whether they think it should be allowed. What they look for is, amongst other things, is whether the invention is new, that is, nobody has done it before or disclosed it before, and whether it's inventive. So this is whether or not there's some improvement, some benefit, some effect, and whether it would just be an obvious modification of existing technology. Really what you should be thinking of here is was any lateral thinking involved? Did we use imaginative solutions? That's really a strong indicator of inventive step. But where you solve any problem, you can often put together arguments that it's inventive. After that, if the patent office agrees, they'll grant a patent, at which point you have a right that you can enforce, and that's when you can really start getting the benefit from it. One very important note, I mentioned it in respect of designs, but it's even more important with respect to patents, and that is, do not disclose the invention before the application is filed. Otherwise, the application will no longer, or the invention will no longer be considered to be new, and you will not be able to get patent protection for it. There are some very, very limited exceptions, but I cannot stress enough that you should not rely on these. So if you're thinking about it, make sure you consider the application before disclosing to the public. And disclosure to the public can mean just disclosure to one individual, not under the obligation of secrecy. So that could be maybe perhaps another person in the industry. So really, it's key that you don't tell anyone outside the company until you know whether or not you're going to go down the route of patent protection. The last major topic I wanted to mention is the other side of patents, and that is, if you are a third party and you're concerned about infringing other people's patents. What we call this is freedom to operate. It's more generally known as due diligence. And it's a task where we will look at ranging from just your key competitors to see if they have any patents, or whether more broadly we look across a range of subject matter to see whether any products that you're developing, or a specific product, or if you're about to use a process, whether that will infringe anyone's patent protection and therefore risk you being stopped from launching, or you may end up having to pay damages, or you may end up having to modify your product or your process later on down the line. So this is something that's often carried out early development phase. In reality, it ends up being right up to launch as product changes are made. But really, you should try and carry it out as soon as possible. And by doing that, you can guide the development process as well based on what protections out there. I mean, the key benefits of this are you avoid or reduce your liability. Nowadays, a lot of our clients see that the investors want to see that this due diligence has been done as well. And they'll often ask, have you got freedom to operate? And what that means is, have you looked at the patents that are out there and determined whether or not there's a risk of infringement? Finally, depending on where you are in the supply chain, you may also need to provide indemnities for your customers. And so in order to indemnify your customers, you should know whether or not they will be infringing. For example, if you make a component that's used in a device, it can be very awkward if subsequently your customer is stopped from selling that device, or they're sued for patent infringement and it's a component in the component that you've sold them that's the problem. So the tips that I wanted to impart to you, because it has been a very whistle-stop tour, but the key takeaways for the patent protection aspect of it is you really do need to keep it secret until you've decided whether or not to pursue patent protection. Fundamentally, that means not telling anyone outside the company, but in practice we understand that that's not always possible, and that you may need to make decisions based on whether or not people can manufacture these items for you, or other components of the supply chain are in place, and you've decided whether or not there's a market. If you're looking at that position, make sure there's non-disclosure agreements or confidentiality agreements in place before you tell the people about the invention, and make sure that it's clear that it's in confidence, because then it's not a disclosure. But to be safe, it's better to decide whether or not to apply before that happens. You can obtain standard NDAs online. I think the government website has examples. So if you're looking for those, you don't need to engage a lawyer, but it is preferable. As with the other types of IP, you do need to think about ownership. If you're outsourcing work to other companies, I know the UK government offers a lot of research facilities, for example, CPI, Centre for Process and Innovation. But if you're engaging anyone to do your research for you, or if you're involved in collaboration with, for example, a university, make sure that it's clear who's going to own the IP. The final 2 points are 2 other advantages of patents. The first is Patent Box. This is a tax relief program offered by the government. It's been in force for about 7 or 8 years now. It's developed quite a lot over that time, but essentially, if you have a patent on an aspect of a product, they will give you a reduced rate of corporation tax. I think it's 10% on the tax burden that would otherwise be in place on the entire product. So what that means is if one component of your entire product is patented, you can receive tax relief on the entire product itself. There are some limitations, and it's more of a question for a tax accountant. So I've linked to the government guidance there, but if you're interested, speak to a tax accountant, or I can pass you on the information that I'm aware of. But it really can be beneficial, and it does extend as well to processes and other inventions as well. Similarly, the government offers quite a generous R&D tax credit scheme. That's a scheme whereby you can claim the tax back on any money spent on research and development. So if you're engaging in research and development, you should definitely be looking at this, whether you're looking at the patent process or not. I think patents often tie in to the R&D tax credit scheme because it's a good way of showing that you're developing and innovating. But both schemes are widely available and can be of great benefit, particularly if R&D is a huge proportion of your spend. So that brings the tour of IP to the end. The idea here was that if you have any specific questions about any specific aspect of IP, you could ask me or email me. I think Claire will look at any Q&As, questions that you put in the Q&A box. But please feel free to ask anything, and I'll do my best to give you an answer now, or if not, I'll come back to you later with a better answer if it's not my area of expertise.
Thank you very much, Mark. Yep, so if you've got any questions, if you can put them in the Q&A box at the bottom. I have one actually to start off, if that's okay.
Okay.
And it alludes to the trademark application that we put in that you mentioned earlier on. Now, I wasn't really involved in that process, so I'm not sure what happened there. But I know that we initially applied for it because there were two companies, I think, that were using Composites and UK in their company name, but also the Union Jack in their logo. They didn't do the same service as us, but obviously they were in the same industry. So I think that's why the application went in. And we were getting inquiries for both companies, which have since closed down actually. But is a trademark the best way for us to protect ourselves from that going forwards?
Absolutely. I should, first of all, just in a typical lawyer fashion, caution that I'm not a trademark attorney. I have a fair bit of experience with them, and my wife is, as it happens, a trademark attorney. But the short answer is yes. For names and brands, the best way to protect it is through a registered trademark. It can be difficult with marks that are descriptive. So, for example, your name describes the industry you're in and the fact you're a trade association in the UK. So it can be sometimes difficult to get that through because the government policy is that if it just describes what you're doing, nobody else should be stopped from doing it. But what you had chosen to do was a particular stylized version, which is much more likely to succeed than just if you had applied for a trademark for Composites UK in Word form. And that is the way to do it. And then you can, if and when that was accepted, I had a quick look and it wasn't rejected for any substantive grounds. I think just somebody didn't pay a fee at the correct time. So if and when you had that registered, and I think you could probably reapply, it's not like patents or designs where once it's out there, you're stopped from going any further.
Okay.
But you would be able to license that to and prevent other people from using anything similar to that.
Perfect. We'll probably look into picking that up again then. I think it was one of our board directors a while ago that was handling it, so we shall pick that up again, I think. There's a few questions that have come through. So can you give a rough cost for patents in the UK?
Sure. So it really does depend on the invention. The IPO fees, the UK IPO fees, they tend to be around £400 for filing, but the real cost comes into drafting the application, that is putting together the claims which define the invention, putting together the description, drawings, and so on and so forth. If it's what we would call simple mechanical invention, it can start from £3,000, including the drafting costs, right up to, if you go to some of the big top firms in London, they'll charge you £8,000 for the same thing. And typically for chemistry style inventions, it's more like somewhere in the middle, £5,000, £6,000. So it can be quite expensive. It depends on the technology though, and the other factor that I find often plays a part is with these incremental inventions, eventually they're all in the same field, so it becomes almost a copy and paste job and then adding in extra examples. So it's safe to budget a fair amount. My applications tend to come in around the £3,000 to £5,000 mark for materials. And then the next stage is that you'll end up prosecuting it, which is the examination phase, and there will be additional costs there.
Okay, any tips for selecting EU countries for validation following a successful grant from the EPO if the cost of a blanket approach is prohibitive?
The cost of a blanket approach is almost always prohibitive. That's a very good question. So just for a brief bit of background for everyone else, once a European patent grants, unlike the EU rights I mentioned, the EU trademarks and designs, which automatically just protect every EU state, the European patent system is different, and it covers a number of member states. And at the point that it grants, you have to choose which countries in the EPC, these European countries, that you want to make the patent effective in. And in practice, what happens is people choose 4 or 5 countries. Typically, almost exclusively, people will go for the UK, France and Germany. There's partly a strategic reason for that. There are the markets that are right next to us and they're huge. And also because you don't have to pay any additional cost for translation. They are relatively cheap. Most of them happen automatically, including the UK. So you don't need to worry too much. All you need to think about is renewal fees. Beyond that, you need to think about where your markets are. If you're not sure, the best bet is to go for the biggest markets. So UK, France, Germany, Netherlands is typical for this industry. Netherlands, of course, is a big port as well. And then beyond that, think about where your competitors might manufacture. So a lot of people will look to Poland, or Estonia is quite common nowadays as well. The downside of countries like Poland and Estonia is that you have to pay for translations of the entire specification in some cases, which can end up being thousands of pounds. So my guidance would be, and this is something that my clients typically go for, is to choose 5 or 6 states and no more, because it's not realistic to go for more than that long term. And if you're filing multiple applications, it's cost prohibitive to go for more than 4 or 5. And in reality, the only companies that do tend to be big pharma. So, for example, this is public information, but if you were to look up the materials clients that I work with, you would see that most of them tend to go for the UK, France, and Germany, and occasionally they'll branch that out to a random other country in which they have a factory, or they know a competitor has a factory or manufacturing plant.
Okay.
Hopefully that was useful. Feel free to get in touch though if you want any more detail, or if you have any specific considerations that you want me to advise on.
You might have touched on this just now, but for you, European Union, UK and USA, do you have to apply in each region for a patent to be covered?
Yes. So the process is that once you have applied for a patent in one jurisdiction, you have a year at first to decide whether you want to file anywhere else. It can be done via 2 routes. You can either go direct to those countries. So if you know that you are going to want protection in the UK, Europe and the US, you can immediately file applications there. Or you can go via an international application route, whereby after a year you file an international application, and that gives you another 18 months or so to basically decide where you think the product might need protection, and to consider the market size really. So you would have to apply everywhere. The only thing I would say is that for the UK and Europe, a European patent can be validated in the UK, therefore it can cover the UK, so it's not necessary to have both. And in fact, if they relate to the same invention, you're not allowed both. There are ways around it slightly by modifying what each patent covers, but you can apply for a European patent. That will cover the UK, and unlike designs and trademarks, that won't change after the UK leaves the European Union. That will stay the same.
Okay, can you advise best course of action for an overseas suspected possible infringement of our patent, where there's a chance that if no infringement, then the party may be a good future partner?
So that's an interesting question. So the first consideration is whether or not your patent would stop any infringement in that country. As I mentioned, they're territorial rights. So if you have a patent that's effective in the UK, you first need to consider whether they're infringing in any way in the UK. A UK patent will cover if it's a product, for example, making the product in the UK, using it in the UK, importing it into the UK, and various other actions. So if they are making it outside the UK and then importing it, or somebody is importing it, then there will be an infringement and you can take action against the person that is infringing. But it only will be possible in the UK. So the first thing to consider is whether you actually have any rights to stop this person. If they're a possible partner in future, you may just want to take care with your approach. There are several laws in the UK that stop you threatening people unnecessarily. I think this is something that you have to be very careful with. So you don't want to go out and threaten them at all. You need to be very passive, unfortunately. So I think this is probably a question for a separate conversation because it's quite involved. But what I would make sure you're mindful of is whether you've actually got any protection in that country or whether they're causing any infringing acts. Secondly, speak to a lawyer about whether or not if you get in contact with them, you'll be threatening them, because there can be some legal repercussions if you threaten unduly, or if your patent isn't valid, or if your rights don't cover what they're doing. And finally, a lot of people can create great business relationships out of potential infringement positions. You can approach them in a way that makes it clear that you think you have protection and you would like to get involved with them, perhaps offer them a license. And we found that there are a number of good relationships that can come out of seemingly hostile, immediate positions. I apologize, that's quite vague, but there are a lot of considerations in a question like that. But I would say speak to somebody, speak to a lawyer, a patent attorney or a solicitor, and they can make sure that anything you're going to send to these people isn't going to get you in trouble.
Okay, what is the argument for a patent versus a trade secret when it comes to a process in your own factory?
That's a good question. The things to consider are, as I mentioned briefly, are whether or not the process is detectable. So if the process imparts a particular property, or if it, for example, if it's a treatment process that makes the final product have something that you can detect. An example might be, say it was a surface, if you were doing a polishing technique that made it have a surface roughness that was detectable and unique to your process, then you might say to yourself, this is something that somebody could try and copy. I would be able to detect if they copied, and so it might be worth patenting. On the other hand, if it's something that your process is, for example, more efficient, but the end product is the same, and you're not disclosing it to anyone, you're not planning to license it to anyone, and the end product is completely indistinguishable from anything else, you might say, it's not worth me patenting it because I would much rather keep it a secret. It's cheaper for me to keep it a secret, and nobody would be able to reverse engineer the process. The difficulty comes if you want to expand, or if you're looking to scale up your process, or in fact, if it's particularly commercially useful and you want to have people in other countries doing the same thing, then one of the best vehicles to do that would be to license the IP rather than selling trade secrets, because trade secrets are a lot more difficult to prove that you had, and you need a lot of documentation, and they could come up with the invention separately.
Okay, I think that'll be the final question. Can you register rights to the design of a chemical or drug, or is it only the process to create them that's patentable?
So that's a good question. You can protect the composition. If it's a chemical or a drug that's new and hasn't been made before, you can protect the specific composition. So that might look like a claim which says a composition comprising, and then you might have a particular backbone and some functional groups. Or if it's a combination therapy style drug, you might have a composition which comprises components A, B, and C, and that will provide you with protection for the chemical itself and however it's made and used. That's quite a broad form of protection. In some cases as well, we have what we call second medical use, which is you can have protection for a compound that's already known but used in a different way. So a drug may already be known, but it might not be known for a particular purpose. And if you've developed it and found out that it can work for another use, you can get protection for that. But then you can also get protection for the way in which it's made. And as you develop it, you may find that particular combinations of said drug with other materials improve the effectiveness of the drug, for example, and you can file later applications as you refine the process, as well as this broad composition claim. I hope that answers the question.
Perfect, thank you. So we've come to the end of our hour. If there's any further questions for Mark, his contact details are on the screen, and you will get these slides anyway, so I'm sure he'd be happy to hear from you. So I'd like to thank Mark for leading on the webinar, and thank you all for attending as well. And we have around a webinar a week coming up between now and the end of August, so please take a look at what we've got coming up, and we'll hopefully see you again next time. Thank you very much, everyone.
Yes, thank you very much.